Good morning, everyone. Am I audible?
Yes.
Yes. Thank you, sir. Thank you. Good morning, all. I am Vidya BS, Assistant Professor, Shishadripuram Degree College, Mysuru. It is with immense pleasure and a deep sense of honor that I welcome you all to this Intercollegiate State Level Seminar on Intellectual Property Rights, organized by IPR Cell in association with IQAC, Shishadripuram Degree College, Mysuru. IPR plays a crucial role in fostering innovation, protecting creators, and shaping the legal landscape of our modern knowledge economy. This seminar aims to deepen our understanding of IPR, explore emerging trends, and encourage academic dialogues on this pivotal subject. I extend my respectful and warm welcome to our esteemed resource person, Professor Lawrence Surendra, Science and Technology Policy Specialist, Environmental and Development Economist, Sorbonne University, Paris. We are truly fortunate to have you with us today, sir. Thank you for accepting our invitation to share your valuable insights and expertise with us, sir. Thank you. We welcome you, sir.
Thank you. So can I start? Vidya, can I start presenting? Hello.
We are not audible.
Not audible.
Few minutes, sir. Yes, sir.
You will have to increase the volume on the other end. I can't.
Yes, sir. So just few minutes.
Yeah, take your time. No problem. Hello, Soumya.
Good morning, sir.
Good morning.
Thank you very much, sir.
No problem. After a
I
long
also
time.
Yeah,
extend my heartfelt welcome to our principal, Dr. Soumya Irapake, whose unwavering guidance and leadership continue to inspire and support every initiate we undertake. Welcome you, ma'am.
thank you.
I also take this opportunity to warmly welcome all our participants, faculty members for joining us and showing enthusiasm and interest in this important academic initiative. Now, let me invite Durga Prasad of third year BBA to read the profile of our resource person.
Everyone. Good morning, sir. Good morning, ma'am. My name is Durga Prasad K of final year BBA. Professor Lawrence Surendra is a science and technology policy specialist and an environmental and development economist from the Sorbonne University, Paris. He graduated as a chemical engineer from Madras University, studied economic history at the University of London, and worked in the area of science and technology policy at the Research Policy Institute, University of Lund, Sweden. Has been scholar in residence at the Dag Hammarskjöld Foundation, Uppsala, and a senior advisor to the Stockholm Environmental Institute, Sweden. As a former HRD expert of UNESCO, has worked closely with UNESCO's sustainable divisions and regard to the UNESCO SDGs and the 2030 agenda as a well-disaster risk reduction learning platforms, taught in several universities in Europe, Canada, Asia, and the Pacific. And it's currently a visiting professor at University Anjingomya University, Thailand. He has been writing extensively on IPRs, GATT, Iran round negotiations, IMF, and the World Bank in the fortline. Round negotiations, IMF, and the World Bank in the fortline, magazine published by the Hindu Group. He has written and published widely in academia, media, and UN publications on the region as well as co-edited books. He has been visiting professor at several institutions of eminence in India. He held the Planning Commissions of India chair profession at the Faculty of Economics, University of Mysuru. Served as a member of Karnataka State Environment Appellate Authority and the Karnataka State Knowledge Commission. On the occasion of Platinum Jubilee of the AC College of Technology, he was one among the 12th alumni chosen to be awarded the Distinguished Alumni Award by Anna University, India's oldest and prestigious university for engineering and technology. He and his wife currently live on their organic horticulture farm outside Mysore. Thank you, sir. And over to you.
Before we begin, I would like to share a few quick instructions to ensure the session runs smoothly. Kindly note that participants' voices will not be unmuted during the seminar. If you have any questions, we request you not to use the raise hand feature. Instead, please type your question in the chat box. Our team will collect them and those questions will be addressed during the question and answer session at the end. Now, I request our resource person to take over the session.
Can I start with you? Hello?
Yes, sir. We are sharing the screen, sir. Just
Yeah, before that, okay. Good morning, everybody. I don't know how many people outside Mysore are on this online discussion. I was actually hoping to speak in person to the students at Seshadripuram College because it could have been more interactive and we could have had some questions and discussions. But now that after COVID, everybody is discovered online is becoming more the norm, though it has its own consequences in terms of electricity consumption and so on. I won't go into it. I am going to do a very basic presentation because I do not know, since it's announced as a state level session, whether teachers and others will be joining and they may find it basic, but it's basically keeping in mind the undergraduate students, which I have tried to cover in this presentation today of about 45 minutes. If there are questions, maybe you'll have to put it on chat or send it on chat that Vidya can figure out how to organize it, and then I can speak about it. So, okay, so let me start with the presentation. I discussed with Vidya, who's organizing this, whom I'm thankful also to Soumya and the others, about what is the syllabi, because sometimes when resource persons come, they can go completely offline. Offline meaning not in the online offline, but off the what is concerned students immediately. But basically what I'll try to do is, next slide.
Sir, sorry for interruption, sir. Sir, please talk louder, sir, because you're not audible properly.
Okay, let me see. Let me check. My mic is fine, I think. I can't. Okay, volume on, please. Okay, like to speak. I'll speak loud, but I don't know whether I can increase the volume on the. Okay, fine. Can you hear me clearly now?
Now it's fine, sir.
Okay, so basically, like I was saying, go back to the slides, and the first slide after the opening slide. Next slide. Next slide. Okay. So I discussed with Vidya about the syllabi because one has to speak around the students' concerns about their syllabi and their examinations and all that, because this is the problem with, even though Vidya correctly and quite appropriately talked about the knowledge economy, we in the academia don't seem to recognize the connection between our academic courses and the knowledge economy. That particular question is for another discussion or debate. So she sent me these 4 points as what should be covered. And I'm not going into any critique of the syllabi because I don't know, there's a lot of discussions or there's a lot of questions, or not, I should say, about how curriculum is prepared in our country and our universities. I've been involved with curriculum preparation both in India and elsewhere, and there are problems in the way our universities, especially in Karnataka, formulate curriculum, but that's again a debate with your teachers. Next slide. So I assume you have read the 4 points in the earlier slide. Let me get into some introductory remarks. I don't want to take anything for granted or assume that you know everything or everybody in the audience knows everything. The question is, what is the difference between actual or real property rights and intellectual property rights? Matter of fact, at this point here, I wanted to go into questions about different forms of capital, which relates also to intellectual property rights, because from an economics point of view, you can have manufactured capital, social capital, so on and so forth, natural capital, and so on. I didn't want to go into all of this and keep it focused within our discussions on intellectual property, though intellectual property very much relates to forms of capital. In actual property rights, whether it's a house or a land, the particular property is available only in finite quantities, meaning there is a limitation. Like land, for example, cannot be enjoyed in more places than one. I'm living on the farm, I can enjoy my land and the farm only here. I can't enjoy it elsewhere unless I own land in some other area. So it is one, finite, and second, it is limited to the place where you are. Whereas intellectual property, on the other hand, is intangible wealth as opposed to tangible. Intangible meaning something that cannot be physical. If we talk of land, we can talk of acreage. We can talk of several things, a house, whether it is 2-bedroom, 3-bedroom, and so on. It is tangible. So, whereas intellectual property is intangible and it's not physically determined. Then, and it can be appropriated by others without depriving creators of that position. Meaning, if somebody comes and encroaches my land, then I am deprived of my land by the encroachers. Whereas in intellectual property, somebody can take the intellectual property I create without depriving me of the position of the intellectual property, which is why it had to be protected by enacting a right. Because somebody else can use it where I'm not deprived, but there is a cost to me. Next slide. So justifications, because let's go before we go into scope and other questions. Why do we need a new class of property rights that we term as intellectual property rights? First and foremost is the ethical consideration that the introduction of IPR constitutes a just reward for the intellectual labor expended in creating or bringing about something new. In other words, individuals get ownership rights as a reward for their efforts in the creation of something new. As I said earlier, an intellectual property right can be used by somebody without depriving me of that property, but then they're using it at my cost. Because I or a group of us, or we work together in Seshadripuram College to create something new, that labor that has gone into it is used by somebody else without having to expend that labor. And therefore, the labor of the people or individuals who have put in their efforts and knowledge and other things to create a particular, for the moment, let's say, a particular intellectual property. I'll use it like this so terms get clearer as we go on. Create a new invention or whatever. I want to avoid using words like new invention because there's too much focus in IPR rights about invention and patent rights. I noticed in the syllabus also. So whatever newly we have created has to be protected. It is also justified economically as a method of allocating value to these resources. If together we have created something new, okay, how do we have to allocate economic value so that we prevent others from appropriating this value, since the cost and labor of reproduction is lower than the cost of creation, which is why even in academia, other than in IPR, we take very seriously plagiarism. Because a very bright student might spend a lot of time producing something, an essay or a particular academic output, and then somebody else just copies it, cut and paste. After Microsoft, cut and paste is very popular. But of course, the person who does it is damaging himself or herself. That's one part. But the more important damage is to the other person who's created something new and it's plagiarized. Plagiarization can be dealt with easily. But when people use other people's creation, then they are losing the value of what they have created, which is why there is an economic justification through IPR to create a method of allocating value to these resources through royalties and so forth. I'm not going into it, how the value is paid, normally through royalties and other things, which at a later stage, some other time we can talk about. As I said earlier, I'm not consciously using the word invention at this stage. Third, creating such rights from an economic perspective is to also ensure that the transfer of this knowledge creates market for this new creative product. So there are two dimensions. One is to ascribe value economic value, and that value is given to the person or group of persons who created this intellectual property. The other is to use this right from an economic to transfer the knowledge and create markets. For example, a new drug, a new product, a whole number of things, which though it has it's owned intellectually in terms of intellectual property rights by a individual or a group of individual or a company, in transferring this knowledge or transferring the knowledge through the products, we create a market. Such a second economic justification for the creating a class of property rights, as intellectual property rights. Second, next slide. Very often I've seen my interaction with IPRs is largely with legal academics and lawyers. Matter of fact, to the time when I started at the National Law School, this was at its height because there was a time of the Uruguay round of discussions. But I find in non-law settings, particularly in colleges and so forth, a lot of the historical background is lost, which is very important because without historical background, you jump into IPRs, trips, and so forth. You don't understand a proper perspective on how IPRs have actually evolved. Earlier we talked about justification. Now I'm talking about the evolution of IPRs. Now, today when we look at the history of IPRs, we see three types of IPRs emerging, which you are familiar with. That is patents, copyrights, and trademarks. There's one more which I will deal with later, which is a more new development. We understand that patents can relate to inventions, but an invention, like in the creation of a particular industrial process, will also have a design, which led to introduction of copyrighting the design. For example, as a chemical engineer, I can tell you that I can create a particular process for producing a product, which will of course have a flow chart as to how the process goes through from the raw materials, processing, whatever stages to the final product. Now that flow chart is a design in a sense. Now somebody can copy the flow chart and create something. So there came the notion in the industrial processes, why talking about it, also copyrighting the design, meaning not only the invention, but the steps through which this invention happens. And that is where we moved from patents to copyrights. But then inventions also create products. And the uniqueness of the product has to be differentiated from others, leading to the creation of trademarks. So you have patents, which creates a new product. The new product has a process, a design, which is can be copyrighted. And then the product has to be distinguished from other products. So you create a trademark by putting a logo or whatever or a name, and now the courts, very often there are cases about on trademark law. And I'm trying to stay away from law at this point, though sometime later on in another lecture, we must have to look at the legal perspectives on this. So that's how you see patents, copyrights, and trademarks evolving. Next slide. Next slide, please. So historically, of course, we were governed by laws created colonial auspices. Of course, in India today, we want to know what happened before colonial law. It's good to know what happened to colonial law, but we should not assume that before colonial law we had everything, like we are claiming in science and technology and so on. And also the notions are very different before colonial law and during colonial law and after, because a very historically demarcating aspect is the rise of industrial capitalism. Even the British who came to us as traders. But when they took over India, they took it over as an emerging industrial power. So prior to the rise of industrial capitalism, knowledge was also created in a larger social sense and in a community sense. Questions of protection did not arise, though it was protected through various other forms, secrecy and so forth. So much as we may try to go and find out how it was protected earlier, we have to understand we're dealing with two different periods of history. History is facing a lot of confusions in this country presently now. It's tragic. But unfortunately, as students, as academics, we have to be very clear what periods of history we are talking, who we are talking, and how things evolve. And this relates to every aspect, also in particular copyright, IPR, because I've seen discussions about whether IPR existed before colonial law and so on. Let's not get into that. So we had colonial law, and which was the law under which our intellectual property was protected. But after independence, we created our own laws for the protections of IPRs because we are now an independent nation and we need to protect our intellectual productions. First thing was the Copyright Act of 1957, and it was India's first comprehensive legislation, you could say, on intellectual property relating to copyright, and comprehensive legislation on copyright. Now, copyright also brings in a lot of legal issues. For the moment, you can see questions about A.R. Rahman's music and he having to pay 1 crore to the court as initial payment before the court resolves the issue of this relates to creative productions like songs and so forth. And very ironically and very tragically and very stupidly, somebody went to try and copyright Operation Sindoor. So, the greed for trying to create money and market out of everything is also a tragic part of IPRs. But the central point is, the person who has created a particular creative product, be a music or whatever, has to be protected. So we did that first in 1957. Protect creative works while balancing public interest. Because you can't also create, protect some creative output, which is also valuable to public interest, which is why we have a time limit on how far copyrights can exist. And okay, this act has been amended several times, notably 1983, 84, 92, 94, 99, to address emerging challenges posed by technological advancements. Here, we are not even talking of AI, artificial intelligence. We're just talking about the normal, linear or evolutionary progress of technology and the need to update the Copyright Act of 1957 to protect it. Those of you who are interested in it, those of you who are interested to go into creative industry and so on, can look at it on your own later, and we may be able to, if come to the college, we can discuss it. Okay. Next slide, please. So, historical background, Indian context. The first law was produced in 1970. It was a landmark law to replace the colonial era laws, and after extensive discussion and consultation, which was hello. Okay, I'm not taking any interventions now, please. So don't raise hands and so on. It's a landmark law, and this is very important to understand the Indian Patents Act of 1970, because it was also unique to developing countries. And then in 1999, we created the Trademarks Act, replacing the Trade and Merchandise Act of 1958. The 1999 Act was harmonized Indian trademark law with international standards, particularly the TRIPS agreement, about which we shall talk about, and the conflicts between our patent law and the intellectual property patent law that came after TRIPS. TRIPS came up with the establishment of the WTO in 1999. And because of which and our adherence to it, we had to make significant changes to our regime. We'll come back to this after covering some important dimensions of IPRs. There is, I know, one item in the so-called in the syllabi about TRIPS that requires a separate treatment. So I will not go into it too much while I'm talking here. But let me proceed further, having mentioned TRIPS, back to IPRs. Next slide. The IPRs became very big and talked about, particularly after the creation of the WTO, particularly for your generation. Born, I don't know when, but the WTO became the dominant discussion, and most even teachers don't tend to talk about IP without tend to talk about IP only from WTO onwards. It's like before Christ and after Christ, AD, BC, AD. So there is no BC, only AD after the WTO, which has a number of problems in understanding the whole gamut of intellectual property protection. The Berne Convention of 1893 is very important, and quite often, even now, people go back to the Berne Convention. Am I missing a slide here? Let me check. Vidya, did you go too much forward? There should be two, no Berne and Penn. Go a little earlier. No, you're going forward. Backward. Go back. Okay, next. Okay. Yeah, you missed this slide. So there's the Paris Convention of 1883, which focused mainly on inventions. Because remember, if we say the Industrial Revolution happened somewhere around 1770, people try to put it very specifically to 1776, because after the Battle of Plassey in 1757, British trade as the East India Company was superseded by the British Crown. And there's in Indian economic history discussions, there's about how Industrial Revolution came, because there were a lot of inventions prior to the rise of industrial capitalism, which were not used till industrial capitalism happened. So you see, with the rise of industrial capitalism, also attempts to protect industrial property. The first attempt was in 1883 in the Paris Convention. Since you're not law students and you're BCom students, you may not be too much interested in the Paris Convention, but it has some connections to what we are talking today. The third is the Berne Convention, 1986. Copyrights. As I told you, copyrights largely protect artistic creation. And it's very interesting that the movement to create copyrights was led by the French writer Victor Hugo. I don't know how many of you know of Victor Hugo and the very famous and beautiful novels that he's written. You can go and check out on your own, because intellectual property is not only about patents and copyrights, which also has very interesting histories in the way creative efforts happened in our world earlier. And Berne Convention is very interestingly, which created copyrights, was because of a French writer, Victor Hugo. Next slide. I think, what is happening here? You just go there. Now, okay, fine. Now, after the Berne Convention and the copyrights that we talked about earlier, together in 1893, the International Bureau for the Protection of Intellectual Property was established to administer the Paris and Berne Conventions. This Paris Convention related to industrial property, Berne Convention related to copyrights. Now, BERP, as we said, is evolved into the World Intellectual Property Organization, WIPO, which was officially created in 1967. The tragedy of our preoccupation with WTO and TRIPS and all that, over preoccupation, of course, it's very important because it has huge economic implications for us in India and developing countries. Granted that we miss the forest for the trees. WIPO is very important, and I'll come back to WIPO later. WIPO is now a specialized agency of the United Nations. It was made a specialized agency in 1974 with the mandate to promote the protection of intellectual property worldwide and to facilitate international cooperation in this field. I will be talking a little more about WIPO later, but I wanted to bring in WIPO because it's something that you should know, and WIPO also puts out periodic newsletters that you can follow. Maybe later on we can do some follow-up in the college with the intellectual property group or club that you may have. Next slide. What's happening? Okay, to recap, we saw 4 areas that were supposedly part of your syllabus: meaning and scope, types of intellectual property, and I've largely covered this through history and what is the scope, why, and so forth. Now, there is something called procedure to obtain thing, which I found it a little odd, and I won't go into too much criticism of it, because this should perhaps be framed as conditions or requirements for obtaining patents. Only after that comes procedure. Then there is a question of IPR regimes and the different institutional frameworks for protecting IPRs that have evolved both nationally and internationally. We won't be able to cover it here, but we must know that special institutional arrangements were created. Of course, there was the patent office created in Madras, but there is also the National Biodiversity Authority, and a whole number of institutions which are which overlap each other. Of course, there's a procedure to obtain patents, but I think the conditions and requirements come prior to question of procedure. Then there is a 4th part called overview of TRIPS. I'm not going into it, as I said, except touching it where it's relevant to our lecture. This requires a separate lecture, and much of my writing in Frontline and so on also related to the evolution of TRIPS. So next slide. Regarding conditions, requirements to apply for patents, patentability, there are 3 parts. 1, novelty. Something that is new. What is said in the IPR Act is not part of prior art. Then it's not something related to something prior. 2, inventive step. Many people get confused about non-obviousness, meaning it should not be, there is a very identifiable inventive step. It is not something obvious that shows, that does not clearly mention the inventive step. There are a lot of discussions, and the question of granting of IPRs relate to this. Novelty may be proved, but inventive step is where many people have difficulties. Also in contestations on IPR, court cases and so on. 3rd is utility, that after obtaining the patent, you're not going to sit on it. It will actually produce it in terms of creating a product or some creative output of it. 3rd is utility. But the another important thing is exclusions, which came particularly after the TRIPS agreement, and also earlier in our own Indian patent law and so forth. But I don't want to go into here because it's a very separate part of patents and requires separate treatment. But it's important to remember that then, other than the 3 conditions or requirements, there is something called exclusions. Another point to note in our Indian context is there is a debate about product patents and process patents. Our 1970 law accepted only product patents, but under the TRIPS, you had to accept process patents. And that is another area for future discussion, homework for you. It's the other way about. we did not allow products to be patented. We allowed only process. So if you are creating a new similar product, if you have a different process, I'm sorry to create this confusion. You could uh, get intellectual property on this. But the TRIPS law completely made it upside down. Next slide. As I said earlier, IPRs cannot be discussed only in the context of WTO, international trade, and TRIPS. They are to be viewed within the larger global architecture of systems of global governance that involve not only the WTO, but also WIPO, the IMF and World Bank, and very crucially, the UN system. We completely are forgetful of the UN system. We believe and behave in this country as if the UN system doesn't exist, and almost as if we don't have use for it. This is not possible and not practical or pragmatic or in our larger interests, larger self-interest as a nation. I won't go into the UN system now, but connected to the latter in different ways is the existing and evolving system in relation to global environmental governance. Because the architecture of global governance, it might be in bad shape now because nobody is respecting the global architecture, not just Trump, others also. I won't mention who all. But that is connected to also the governance of our planet, of our ecology, of our environment. We can have the best intellectual property rights, but if we are all dying of global warming and climate change and so on, it's of no use. So we need to protect ourselves, our nature, our ecology, and that can be done only with protecting the ecology of the planet Earth. Because, for example, after climate change, there's nothing that is national or local. Everything is part of the global climate change. So there is a global environmental governance becomes a very important part in the architecture of governance. And there are a whole set of global conventions, uh, uh, a large number, which I'm not listing. But I think here in our context, what is very important are the biodiversity conventions and the 20 plus environmental conventions, treaties, and agreements. So we cannot discuss IPRs without discussing global environmental governance. That's something to be understood. Because in that context also some exclusions come. And the exclusions are many. And there is a need to go through deeply. But then I don't know how much BCom students get interested about environmental governance, though I know individually you might have a great concern for the environment. But environmental governance is so important and determines our daily life wherever you are. And that is perhaps something we have to deal with separately some other time. Then thirdly, there is a WIPO related treaties and conventions which amount to 28, including the WIPO convention itself. I said earlier that we are so focused on WTO and TRIPS, we forget WIPO and the WIPO related treaties and conventions, which are 28. And they do impact and impinge on the TRIPS agreement. It's not as if TRIPS is the mother of all laws, as they used to say when it came, mother of all treaties. There's no mother of all treaties. Okay? So this, you have to see it within this jigsaw puzzle, as you like, of IPRs within all the other pieces of the jigsaw puzzle, which I've mentioned, whether it be the other multilateral institutions, the IMF, World Bank, WIPO, and very important, the UN system, which is the system that works in what I call the normative part. Meaning, what should the world be? The WTO and so on are positivist. The world as it is, and let's deal with it. Like the current discussions on tariff. This is the world as it is. I don't like it. I want to change the tariffs. Then you go off on your own. But there is another issue about what should the world be? How should tariffs be connected? How do you evolve it? So this distinction between the UN system as a normative system, normative meaning what is the world that we want, to the positive system, the world that is. This is also a very major discussion in terms of social science. I just want to mention it in passing. I wanted to have a separate slide, but I didn't want to take you too much out of our focus on intellectual property rights, but I'm just mentioning it as part of the my talk in this presentation. Next. Continuing the couple of points. The current IPR regime within the context of the IPO came with the Marrakesh Agreement that concluded in 1994 and overtook the previous international mechanism for trade, what we know as GATT. When the Uruguay round talks were going on, it went on from 1986 till 1994, almost a decade. People used to say, call it go and talk, because it is in the Uruguay round of GATT negotiations. Everybody tried to see how much they can to shape the WTO and the WTO provisions on IPO. GATT has not disappeared. It still exists as the umbrella treaty for the WTO. So the original intention was that GATT will disappear and WTO will take over, will be the trade organization. Historically, after the World War, Keynes, the famous economist, John Maynard Keynes, in a suggestion for looking at economic governance of the world, actually suggested three organizations: the the IMF, the World Bank, and what he called the ITO. But the ITO, International Trade Organization, that didn't happen. We had GATT, and GATT survived till 1976. And the history why it happened is another very interesting history. I won't go into it. We've written about it a lot. Why GATT came up and what was attempted in GATT and so forth. So we have to talk about the creation of TRIPS and WTO in linking to the Uruguay round and GATT. Because the Uruguay round discussions were very different. See, we call it Uruguay round because in the GATT negotiations, each round of discussion, there was the Paris round, there was the different rounds. Each round, there'll be an item. There'll be maybe 30, 40 items which will be negotiated. Not all items will be fully resolved, and then you go into the next round. The distinction between the Uruguay round and the earlier rounds and the Uruguay round was, one, all items had to be discussed, and two, new items were introduced, such as agriculture and intellectual property. The earlier GATT discussions, intellectual property and agriculture were not part of the negotiations. It was largely on tariffs and trade. So the WTO treaty was a very ambitious treaty, and it which created TRIPS and TRIMS. TRIMS is a trade-related investment measures, which is another controversial aspect of WTO, but we are here dealing largely with TRIPS. And by bringing in agriculture and intellectual property, it had a whole number of implications. For example, within agriculture, how do you deal with seed innovation within the ambit of IPRs? Seed innovation is done both in nature and by individual farmers. How do you bring it within the ambit of IPRs? So these are the kind of problems, issues, complications that came up with the emergence of WTO from GATT. Next. I'm going into this. I mentioned this to the college principal Soumya and maybe to Vidya also, that as BCom students studying in Karnataka and in Mysore, you have to look at IPR in the context of agriculture. Not only because we are a predominantly agricultural economy in a national sense, and especially in a state sense, agriculture in Karnataka is very unique. It is one of the few states with a great diversity in agrobiodiversity. We have almost 9 agrobiodiversity regions. We have drylands which may be equivalent to some of the deserts of Rajasthan. And a lot of our well-being, our economic advancing is dependent on agriculture. Don't get carried away by IT and what's happening in Bangalore and the mess in which Bangalore has become. This is in terms of looking at your own future and the kind of opportunities you have, both in terms of your self-interest and in terms of larger. Who is this raising a hand? Please close it. So, uh, uh, so this is in a specific our own context. It's important, but in general also it's important. First, the distinction between nature's created invention came into prominence in relation to seed and plant varieties. I mean, on my own farm, I have two flower plants next to each other. After some time, they do natural hybridization, and you'll get a third plant with half the color of one plant and half the color of one flower, half the color of another flower. Nature keeps on producing hybridization, okay, which produces, of course, new seeds, new plants, and so forth. You can also do hybridization on your own in an individual sense. But this is something that's happening by by using nature's ability to create and, in a sense, inventing that. If you look at an individual farmer's sense or farmers as a community, which is why we say the knowledge of seeds and plants are part of traditional knowledge of both communities as well as knowledge systems. Many of the rice varieties that we have today are there because our tribal communities in places like Orissa, Koraput, Chhattisgarh, and so on, where we are literally finishing off the tribals in the interest of mining and so on, were available to us because they managed to keep these seeds and plants and transmitted that knowledge to us. And it is from the original seed varieties that we can create new varieties. If we don't have the original seed varieties, no scientist can create in a lab a completely new seed variety. So traditional knowledge of communities becomes extremely important. Then we have the other issue of knowledge systems. My own work is basically on the politics of knowledge systems, and in which context IPR has also become important. We have in our country, for example, knowledge systems are unique to different cultures. It be Africa, Latin America, so on. Each of them has. Let us not try to pretend or try to boast and beat our breast saying, oh, we have everything, we have done everything, the world is not done. My generation is very disgusted by such discussions. And please bring some modesty and modicum of understanding the world in a larger sense. We are not the only human beings in the world. Indians are not the only human beings in the world. We are part of a larger global family of culture. So everybody has their own cultures, which we need to respect. And we borrow also. And none of what we have is unique. It has also come from transfer, whether it be Ayurveda, Unani, Siddha. They've also come through a certain give and take in knowledge systems. But the point is, we have traditional knowledge, we have knowledge of indigenous communities, we have our own knowledge systems, which is why we in the IPR discussions in TRIPS, the need for exceptions came up. Now that's again a large area of discussion under TRIPS regarding exceptions and the conflict between the market commodification oriented perspective of TRIPS and the larger biodiversity, social benefit aspect of other knowledge systems and institutional arrangements. I'm just mentioning this because this is also another very complex aspect of discussing IPR, which maybe when you go into the second year, third year, and so on, there'll be opportunities to talk about it. Next slide. Next slide. Next slide, please. So continuing with the implications. No, please don't jump. Hello, go back. Go back, please. Go back. Yeah. My God, what's happening? Let me go to my own slide and look. Slide 16, please. Slide 16. No, you have to go back.
Sir, this is a slide 16, sir.
Okay. Thank you.
No, cannot be. We have implications for IPR, that is number 1, 2, 14, 15 rather. Sorry. The 2 more points related to bring agriculture. You got slide 15?
Sir, is
Yeah. Okay. So earlier we talked about point 1 and 2 in relation to agriculture. Let me look at my slide and talk a little bit. So we talked about in the earlier aspects to nature creation and invention and traditional knowledge, community knowledge, and knowledge systems. One of the implications of bringing agriculture into the ambit of intellectual property discussions. Then there is another important issue. Question about public domain. This is also a very, very important part of intellectual property. Again, needs a separate discussion. Public domain, now of course with modern technology, information and so on, the notion of the public domain has itself transformed. Okay, but just write down your questions and then put them later, please. Because when your questions pop up while I'm talking, I find it disturbing. Hello, Sinchal Gowda, I've covered all this. Don't interrupt with your questions now. With your chat, write it down and put it on chat later because it's very disturbing for me while I'm presenting here to come up with your questions. And some of the questions are because you're not following what I'm talking. The implications of IPR bring agriculture within the scope of TRIPS. There's the issue of public domain, meaning a lot of farmers created seed varieties and so on so that larger communities can use it. And this was a major discussion in the TRIPS agreement also, because private seed companies would like to privatize the seed knowledge and sell it as commodity. How do you prevent it? One. Second is, by doing so, which is a major controversy within the TRIPS agreement, is you are making my life as a farmer dependent on private companies like Cargill and others who are making seeds, me dependent on their seeds. This is a vast, huge area and very interesting area to discuss. I don't have time to go into it. A lot of James Bond stories in this part. And we actually will be publishing a 3-volume book as Plants, People and Ecosystems, which comprises all the discussions that happened on questions about agriculture, public domain, seeds, commodification of seeds, and so forth. It's good for you to keep in mind because tomorrow you may be working in a seed company. But when you work in a seed company, you got to know what are the ethical dimensions and what are the legal dimensions of how seeds are used, which is why in many states, the state has taken over seed distribution. Current fashion says, oh, state should not involve in this, state should not do that. there's a lot of nonsensical discussion in the current generation about damaging the state. State has certain roles. It has some important social, economic roles. And it has, more importantly, in a country like ours, maintaining equity, access to knowledge, and so forth. So this is again a separate discussion, because anything that the state does, we immediately say, oh, this is freebies, this is that, which is very irritating to my generation, because this, and particularly with social media and the echo chambers of social media, people don't want to look into a more balanced discussion on what is in our interest, what is in a larger interest, and now our interest and larger interest combines to larger national or international interest. This is a very large discussion. I'm not going into it. I'm sorry. I'm using some very large, very judgmental terms. But because this is, when I look at in this history of what is going on in the current kind of discussions, it's little awkward and irritating for people like me. Then number 4, there is the conflict between global environmental treaties and conventions for the protection of nature and sustainable development. I already mentioned Biodiversity Convention, and that conflict had to be resolved, bringing new concepts for the management of IPRs, such as sui generis. Sui generis is something that you will need to understand, because a lot of exceptions are given, as I mentioned about the exceptions, based on what is called sui generis, meaning it has a particular history, it's a class of its own, it's unique, and so on. Even lawyers sometimes don't understand it too well and it is confused. But sui generis was a concept that was introduced within the TRIPS discussions in the context of the larger questions about nature, protecting nature, and so forth. And also sui generis in terms of our own histories, our own knowledge systems, and so forth. Next slide, please. So now I come to, in taking IPRs and putting it in a larger context of not just TRIPS and WTO. Anyway, the WTO is now facing a lot of problems, not because of Trump and tariffs and so on. Quite a lot of what were originally WTO provisions are being chipped away by other trade agreements. That's another discussion, whether it is good for us the WTO gets weak, or it's bad for us the WTO gets weak. A totally separate discussion. Maybe you can Google some of this on Frontline magazine. Maybe you should subscribe to Frontline magazine, because it's perhaps one of the magazines that deals with many of these things in depth. And also it's good for you. I mean, I know people who want to do IAS and KAS read Frontline, but beyond that, it's also useful. So a lot of the discussions on questions about the conflicts in intellectual property protection that rose within the context of IPRs, in the context of WTO, are found there. And I like to place IPR within Sustainable Development Law. Of course, there is no specific Sustainable Development Law, but one can see it as an interconnected web of laws that seek to protect nature, biodiversity, and the planet. Again, examples are, I mentioned Biodiversity Convention, climate change convention. It's basically called the UN Framework Convention on Climate Change, UNFCCC. Why it became framework is another discussion on how conventions evolved. Kyoto Protocol, which has to deal with hole in the ozone layer and so forth, and the law of the seas. Just to mention a few. Going back to biodiversity, because that has relevance to us in the discussion of agriculture and nature, there are issues such as conservation. I conserve seeds. I, as a farmer, you as I'm sure many of you come from farming communities. Your father, mother conserve seeds over a period of time and make sure the seeds are available. You want to give it to somebody else, you may do it within the family. But there is something that people have done by conservation, and when what they've kept as conserved needs to be shared by larger, they need to get some benefit in the benefit sharing. That's one dimension. In the Biodiversity Convention, there is the one clause on access and benefit sharing. Traditional knowledge, we have referred to it, which is a very huge area within biodiversity. And because of the Convention Biodiversity and an article called Article 8 I and J, exceptions had to be provided in TRIPS. Technology transfer and intellectual property rights. Technology transfer, particularly in relation to seed rights. But there are scientists who also decide that they don't want the intellectual property to be done within a particular intellectual property framework, but given to a state institution like the National Development Corporation. I can think of my own teacher, Dr. C.V. Seshadri, who was the one who did this, from seaweed production. I'll get the name in a while. And he decided that his intellectual property for that will be with the National Development Corporation and not with any private entity. Okay. So there are people who also do that, saying, I don't want it to be privatized. I don't want it to be commodified. I want to make it available for the. Even in the case of our COVID vaccine, there are problems about it as to why we gave the COVID knowledge to private parties. We had the Hafkin Institute, which is world famous, and African countries talk of India, no Hafkin Institute. For some reason, we didn't give it to them. We gave it to private parties. Maybe because our own countries are shifting their thinking from larger national interests towards mostly private and commoditized interest, which may affect you, which you may have to figure out, which you have to understand. Because that's the future for your generation. If something so critical as a vaccine is to be given to a private property, then where is the state's role in protecting health? So on. I'm just spelling it in my passing, though I'm not going into health and human rights here. These are all the implications that follow the notions of intellectual property and its conflicts with public rights, public social rights, and so on and so forth. Next slide. In our own context, we don't have a specifically sustainable development law, but we are governed by treaties and conventions that we have signed, other than the WTO treaty. We have signed the Biodiversity Convention, we have signed the UN Law of the Seas, we are signatory to the Kyoto Protocol, and so on, for which we have to introduce corresponding domestic law, which we have done, as for example, the National Biodiversity Act of 2002, and which addresses the challenge of IPR regimes through establishment of institutions such as the National Biodiversity Authority. But it so happens in the case of IPR, I'm sure in others also, many of these contradictions, conflicts, creation of new institutions, exceptions that I'm talking about, can be understood only by understanding specific cases and case studies. There's some very, very interesting case studies. For example, the herb that was produced by the Kerala tribes and the whole question of protection over it. A lot of people have done work on it, and it became a big part of the discussions on intellectual property. So maybe you can yourself look at case studies and have some discussions on your own, or maybe with your teachers we can guide you into looking at it. But case studies give you a better understanding of what I'm talking about. Next. So some of the points that I want to, things that I've left. I mentioned earlier, other than the 3 dimensions of intellectual property, a 4th was added in the evolution of IPRs. We mentioned patents, trademarks, but we have a 4th class of IPRs, which is called geographical indication or GI tags. This also has tremendous relevance to us in Karnataka, and maybe very good work can be done on this for those of you interested later on to do more work. GIs connect a product to a particular geographical region, and which connection can be due to factors like the region's climate, soil, traditional methods of production, or even a unique skill or heritage, for example, like weaving, textiles, so on, passed down through generations. For example, certain forms of mat weaving have been given GI tags. A particular type of jackfruit produced in Tamil Nadu has a GI tag. Karnataka has 46 GI tags. Tamil Nadu has 69 and Uttar Pradesh has 79. Go and find out what are these 46 GI tags we have. What are the possibilities that could be done more? So there is, IPRs is way beyond just patents, copyright and trademarks. There's so much in the larger field. That's why no. So GIs also opens it up much more. Next. Next slide. So I'm coming more or less to my end of the slide. I've not been able, I mentioned about COVID vaccine and I felt the wrong way in which we did it, which we are not at all. No, there have been very good discussions by doctors and public health specialists, but that's a different. I've not been able to deal too closely about medicine, health, pharma products, especially in the post-COVID era with regard to IPS, and which is something you can try to understand yourself. I'm sure there are people within this huge group who are more interested in equipping themselves, empowering themselves by trying to understand this more. Because you are an internet generation. We had to run to libraries. You just go to Google and you get all your answers. But then the answers has to be put within a perspective. Google will tell you many things, but you have to put it in a perspective. You can try to do that, which is why you come to a college for education, because college education tries to put this so-called huge knowledge world outside into context and also see the relationship. But I'm not going to health and so on. We can go into it. Maybe another time we can learn. Second, challenges remain in relation to agrobiodiversity, traditional knowledge systems, and protection of our bioresources, be it plants, animals, or other natural biodiversity. People come to our country and take our ants and go to their country. It is illegal. It's not to be done. But there are European countries that want to do research on our land, on our ants. I'm saying this, how such a small creation of nature is of interest to others for many things. Now they have to be protected from privatization and commodification, but also because they're also an important basis for production of new products through biotechnology and gene editing. Recently, we have introduced a new rice variety through gene editing. Gene editing, according to this very famous scientist in Dr. Balgu in Hyderabad, is now being used also for relation to eye problems. So there we'll have to see, there is a whole lot of challenges remaining in terms of how commodification is necessary, of course, in the sense that if I were to create a product, I need to get the benefits of it. But how much is the conflict between commodifying it and excluding it from public use, as in the case of vaccines? That is something that needs to be looked at. Then challenges posed in artistic creation, the advent of AI. This is a separate topic by itself. The last word has not been written on it. There's too much also made of AI, and there has to be a balanced discussion. But there is, in relation to IPRs, a huge area to be worked out. And lastly, how to update knowledge in our, I say, broken educational system in relation to issues such as IPRs. Whether our educational system is broken or functioning well or healthy, it's up for you to find out. But this is my kind of view on it. So that is the fourth challenge. So thank you. Last slide. Oh, sorry, before that. Yeah, these are some of the websites that you may interest. There's a very large number, but I just picked few. South Center is the center that deals with countries in the South, meaning developing countries, and has a whole lot of excellent reports in relation to IPR. and I closely associate with them. We have done seminars. I've had a long relationship with them. But this is somewhere you can go because you'll get other perspectives. One problem with the so-called internet world and Google is our minds are also, too much of uh, perspectives that don't relate to really our own realities or completely market oriented. So you need to get many perspectives. WIPO I've already mentioned. WIPO has an interesting and very good newsletter, which I'll send to you. You can go there and look and whatever it is. And WIPO now has excellent seminars also, which you can log in and attend, where you'll expand your knowledge on intellectual property far beyond trips and all this kind of limited issues. UNCTAD is central. It is the UN Conference of Trade and Development, and which also plays a very important role from a UN perspective and very important non-market perspective in looking at all these issues, because technology transfer, there's a division on technology transfer, a whole number of issues like that there. The last is a UN site which relates to cultural rights, intellectual property regimes, science and culture and so on, which may be of interest to some of you, and there are scope for you to expand further into it. Okay, I took a little longer than I intended. Anyway, we didn't start at 10:30 sharp. Oh, I should have finished by 45 minutes. Anyway, I hope, thank you for your patience. And that's it. Just keep the last slide going. And you can have questions. Next slide. Yeah, now there are chats, is it? Vidya, how do you want to deal? Are there any questions?
Yes, sir.
Ah,
Thank you so much, sir, for the insightful session. Now, let's have a question and answer session, sir. Now, here is the first question. Question is from Puneet. How does IPR contribute to economic growth?
I dealt with it much earlier in the slide because it provides it assigns a value, it makes something part of transfer through markets, and IPR protection is very central to economic growth. Because if inventions that we do in our country, in your lab or somewhere, is simply hijacked by somebody else, here we lose the benefits of it. So which is why in our own context, we need to have strong intellectual property laws, but also make sure that our intellectual property laws are not what you call eaten away by WTO type of laws. Because WTO type of laws is also to create a global market in the context of globalization. And I've gone through the entire Uruguay round and I've written a number of articles. It was amazing how private interests based in the US were the ones negotiating the WTO discussion. For example, when the WTO discussion first round started in Brussels, Uruguay round, our countries as usual send our bureaucrats who are well informed, in particular in our country, extremely competent. I'm known with them, I've interacted with them. They arrive there and then they see the US sends all company representatives of multinationals. So the first, there is a discrepancy between whether it's sovereign states discussing World Trade Organization or market entities discussing a World Trade Organization. So in those kind of contexts, of course, the more powerful multinationals and others will take advantage of us. It is our interest, and we cannot entirely trust our state also, because our state also will be influenced by different kinds of interests. And if you don't want to you don't want a country to be playing only to active interest groups, then we need larger public knowledge. And I'm happy to say that during the Uruguay round discussions, there was massive public discussions. There were books, there were articles, and that influenced heavily our negotiations. And there were also bilateral discussions of economists between Thailand and so on. So intellectual property rights are extremely important for economic growth. But for that to happen, we have to make sure two things. One, we are not giving into too many external interests. We are not giving into only private interests, and we are able to balance public interest with economic interest, which might be individuals also. Certain areas, for example, Mysore could be a big region of creation of intellectual property. Then we have to have special provisions for it. I know other countries have it. I've talked about it over 10 years about it. Zones. The GI tags, we get it, but who's following it? So definitely, of course, IPRs has very major contribution. It is, you can't wish it away saying, no, 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 it's private property rights. So we're going to undo it. We live in a world of private property rights. How within the private property rights you protect both individual interest and larger social national interest. Next
Yes,
question.
sir. Here is the second question. What were the key reasons for introducing IPR discussions during the Uruguay round of GATT?
No, the question should be rewritten differently. Okay, in a sense, yes, because the Uruguay round was an attempt by global powers, especially the US and UK, and definitely some European countries, to make sure that there is a globally accepted rule or regime for intellectual property. It's a well-meaning intent, there's no problem about it. But the problem is when they introduce intellectual property rights, they wanted to bring it in terms of their intellectual property rights. I talked about product and price, process patents and so forth, a number of other things. They wanted to bring, other than intellectual property, agriculture. Agriculture not only into the WTO discussions, but also within intellectual property. And some of the major conflicts arose there, and it is still not resolved. So IPR was brought in because the West also wanted to protect its technology. West felt that we should pay more for their technology. We had transfer of technology arrangements with countries which were bilateral. But the Americans felt that no, whatever technology you take, you have to pay for it, and you have to pay it through an agreed IPR system. So IPR became central both for transfer of technology, the creation of new technology, and our ability to innovate new technology. For example, the Japanese. Yeah, Vidya? Okay, so you want to close.
Sir,
In
please.
case of the Japanese, they copied a lot of things. A lot of Japanese technology developed by copying. But after the World War and so on, they wanted to change it. That's one of the reasons. There are many, but there are time limitation. You have to close soon. I won't go very far. Next. Last question, maybe.
What challenges do developing countries face in enforcing IPR laws?
Oh, it's a mega question. There are one, of course, we have to look between in enforcing IPR. Of course, we have to protect our own IPR. That is number one. Second, we have to protect our own knowledge systems, as I told you, traditional knowledge, community knowledge, indigenous knowledge, our knowledge systems. You know, this big debate over neem. Even the humble idli was patented in the Massachusetts Institute of Technology. Idli is community knowledge, indigenous knowledge. It's unique. It is part of the fermentation technologies that Asian countries evolved over a period of time by innovation. So the neem question was resolved. But there are a number of challenges that come. But before that, we have to set our house in order. We have to say, what is our national interest? There's a big difference between breastbeating about nationalism and selling our national interest. The more you breastbeat nationalism, quite likely behind the scenes, your national interest is being bartered away. So you have to find out in the context of innovation, in the context of creative stuff, in the context of artificial intelligence. What are national interests? Of course, our national interest will be represented by bodies like NASSCOM and others who are doing a very good job. Our IT industry has done a fairly good job. Many of our industry associations do it. But only when larger public get into a knowledge of these can we have a bigger public debate, a more democratic debate, and make sure that everything is not decided by social media trolls. It is decided as part of larger public debate, parliamentary debate. I don't even know who is the parliamentary committee now on IPRs. I have to go and find out now that you ask. But this is all discussions definitely for this generation of students and others, because the world is before them. For us, the world is behind us. And they have to seriously figure out if they are to live in this country and figure out a way to navigate it, keeping national interests and not just nationalism in mind. How is national interest defined? How is it related to issues like IPR, and what can be done? But this is a too mega question. I can only give you some off the cuff remarks like this. I hope it satisfied your expectations of this lecture.
Thank you, sir. Am I audible, sir?
Yes, I can hear you.
Okay, thank you. Now we are at the end of this seminar. It's my privilege to deliver the vote of thanks. First and foremost, I extend my heartfelt thanks to our esteemed resource person, Professor Lawrence Surendra, for taking time out of his busy schedule to share such insightful knowledge and perspectives on IPR. Your expertise has truly enlightened us and added immense value to this seminar. Thank you, sir.
Thank you.
I would also like to express our sincere gratitude to our respected principal, Dr. Soumya Arappa K, for the constant support, motivation, and encouragement that made this seminar possible. Your presence and leadership are always a source of inspiration for us. Thank you, ma'am. A special thanks goes out to all the participants from various colleges who joined us today. Your active involvement and enthusiasm have greatly contributed to the success of this event. Thank you all. Behind every successful event is a dedicated team, so a big thanks to our technical team for ensuring the smooth execution of this online seminar. Once again, thank you all for making this seminar a meaningful and successful one. Wishing everyone continued success in your academic and professional endeavors. Have a great day. Thank you.
Thank you, Vidya.
Dear participants, to receive your e-certificate, please complete the feedback form using the link provided. Please note the feedback form will be remain active only until 2 o'clock today, 2 p.m. today. Thank you for your participation. Thank you all. Have a good day.